the first to know Nsem-Pii TV.
Me mamu, very good morning by Nsem-Pii TV so. Enra na okoko piemu oye mrashe bedwafia na adaje eni epuso kura the Speaker of Parliament Yera Kingsford Usmana Bagbin declare NDC amunyokuno minority in Parliament no majority na NDC NPP so majority in Parliament no o declare omo minority. Now prior to that no na name say Nsemba ko mienu miensa ekoso mrashe bedwafie efa independent and sitting MPs bia December 7 general election no omo ko as an independent nenam so na NDC amonyoko no eteki action against that. Now before that you say majority leader era afenyo markings efa krata command Supreme Court na nyoma bia ebeba mrashe bedwafie interpretation bia Supreme Court ana edi hu dwuma enti eno nam so majority leader era Alexander afenyo markings fale krata mebe na kodan Supreme Court say omunhwe na omunfa decision and omun take decision ema omun mrashe bedwafie ni ehu de akote bayire mama bayire amo na ye name say speaker Yera Kingsford Usmana Bagbin oye NDC ni nti no pese NDC amonyoko no ebe majority in parliament one omo akọ in backdoor akọ hiem akọ di nkomo bia na or declare a seat nyina vacant se be ya NDC amonyoko no minority in parliament no eba be majority na nam so say they said the speaker of parliament Yera Kingsford Usmana Bagbin wagu Supreme Court no enimtia anase ongu omo enimtia yenko ni nkoti oman ni yodubu achi odidu mama so perfect ene one na bidwa fortness no maba bansemu nyoma ekoso mrashe bedwafie say Supreme Court and take action on that na Yera Kingsford Usmana Bagbin ene NDC amanyoko no afa ho no declare NDC amanyoko no as majority in parliament yenko tie
of parliament or parliament itself that they have changed their allegiance within the house. Filing a nomination to run as an independent or another party's ticket in a future election does not amount to severing an alliance with the current party in parliament. Prior to their nomination filing, the house was balanced at 137-137-1. And it remained unchanged after the filings. This demonstrates that filing a nomination is merely an expression of intent for a future political cause and does not alter the MP's present affiliation, obligation, or duties. The MPs remain bound by the social contract formed when they were elected and continue to serve their current term under their mandate. Parliamentary allegiance is determined by an MP's actions and conduct during the current term, not by a future aspiration. Until an MP officially changes affiliation or resigns, their role and loyalty within Parliament remain unchanged, irrespective of any nomination they may file for a future electoral cycle. To interpret a future nomination as severance of present ties would be a misapplication of the law, confusing future plans with actions that have not yet been realized. Article 97(1)(g) and (h) of the Constitution are concerned with actions that affect the numerical composition of the House, aiming to avoid situations that disrupt the voters' verdict. If the electorate has voted for a balance of 137-137-1, MPs should not unilaterally disturb this balance, and those who attempt to change it during their term must vacate their seats. The underlying principle is to prevent mid-term shifts in allegiance, ensuring stability in parliamentary representation. The law is not concerned with future intentions or electoral ambition that will only take effect in the next term, such as an MP running under a different platform in the next election. The timing of actions is critical here. The phrase joins a political party refers to an MP actively affiliating with another party during their current term in parliament. It does not apply to future political affiliations that will take effect after the current term. If the law were extended to include any future action, such as running for a different party in the next election, it will unjustly limit MPs' ability to plan their political future, which goes beyond the law's intended purpose. The law's primary goal is to fix an MP's allegiance during the current parliamentary term, reflecting the mandate given by voters. Actions taken after the term, like joining a party for a future election, do not interfere with this mandate. The law serves to preserve the trust voters placed in the MP when they were elected based on the platform they represented at that time. Moreover, Article 97(1) reserves questions about the vacation of seats to the High Court, while matters like death, resignation, or dissolution do not present questions and are handled by the Speaker or Clerk. Factual determinations such as discerning an MP's intention from the action are not within the Speaker's purview. This ruling set a dangerous precedent, undermining MPs' ability to plan their political futures without fear or immediate consequences. It allows the arbitrary decisions where filing a nomination for a future election could be misinterpreted as a shift in allegiance, regardless of the MP's current conduct. This broad interpretation risks destabilizing parliament by prematurely vacating seats, disrupting voter established balances, and eroding the principle that MPs serve their full term unless they explicitly change allegiance. It could also create a chilling effect, deterring MPs from exploring future political opportunities. Additionally, this ruling contradicts the fundamental right to freedom of association, including the right to join parties and pursue a future political affiliation. Treating a nomination for a future election as severance of current allegiance unfairly penalizes MPs and discourages political participation and realignment. This undermines political pluralism and erodes key democratic principles. Finally, the ruling is also problematic because Article 1126 states that a by-election shall not be held within 3 months before a general election. Vacating seats so close to an election is an affront to this provision, creating unnecessary disruption and leaving constituencies without representation during a critical period. It undermines the intent of the Constitution to maintain stability and continuity in Parliament as the country prepares for national election. His name is Professor Azar. And Bagbin etna James say minority educator between invoke Article 97 GH. One also so say MPs no a file or nomination e be as independent me and sana ba ka ho 9 ntino one mo abu parliament mraso yen hwe sem ni say uche Professor Azar or say sad decision no take no it can only affect a foreseeable in parliament sambre we no omo representing omo crofo and a 4-year term no so ya utimi ka say obi akofile nomination as independent of forfeiting the seat. One, Saudi panel a informal speaker and on side informal parliament say was shifting position. Now allegiance is no more with the party. And a current parliament no was it's a nomination of finally you know. Professor Asasu Obusa say a for elections e current na say future. Say the future there Ebienu okwana wo Bagbin wonye speaker. Why do you take a decision for a future parliament when you are not the speaker? 2, or say basa undermining freedom of association. and a MPB or no office any party muano. Na dachi bi obeso okodon party bi na nti okọ election office party na no hana ontumi nye enti ema ono soso MP no nsa yetia a oni tumi obetime tu sana mo wosaso ka bi o say eye political party na woso otimi de krata akoma MP ni say we wa bitire yen enti Bagbin no eni the purview say ono na be interpret intent and purpose of an MP. One day I was say interpret what two sana mono. Majority say omo a boycott to parliament. They will not go to parliament again until Supreme Court ever take a decision. Majority leader Afenyo can say of file Rita. Now was here say vo a year speaker. Okopie one more and Speaker so catch and say, we are very much aware, say, Yanis Chief Justice Achuchin Komama, Omunina Diakobi say, a Jordan Kwa, and Obetima Sevo Speaker now parliamentarian be a rich. I won't we away. I said, we buy up a so giddy, Echo Fahona Koye. Now, and no out here a Yakati Hamonda. Was it Bagbin the assembly ban or the Asama Banso? It's your name come and say, Fia, Mijidi say. Majority ebe ye former minority yente ketiamo
interpretation constitution means say bibia baba bia interpretation bia na Supreme Court na kan wanza ya kasa de we say no ya de majority leader wanya de krata ni na come Supreme Court man time kakra ma wo Supreme Court time kakra na wo decide ade we tia de da ya ba ya be kan wo so wo dwene ho akwata na bi wa frefre wo ndc fo a woni mo obno kekrekekrekre ma twatwa nyoma original kan mu azese mo de aba ba ko na ko no mo huri ye wo say majority ya yi Ghana fo ato aba ma ye majority ya ba tell them ha ya ba tell them we say e da wo say my minority ko ko tin sa asem bu we fa ba be di asem ba ma mu ha wo di bia ba ne ama mo keti ya mo say ya sika nya ni sa wo say ya be so mo extending orders. President na no kan what I want to present order bia. Stand orders on one the ultimate interpretation. Constitution no. You say bibia ye law, ye constitution dan kasa ba interpretation bia. Ye Supreme Court na kan you na kan wa ha. We say as say obi change na oso okoye independent say ya just what for declare na yi. Ye nyina lawyer for bia wa na adwene. Enti na court ni constitution na ashembra say sa dey say the ba lawyer for bebre na say bebre kan o ma be ka ho. Another for na nketo baro nyina lawyer for wo kuro obi awa na agwere nko ebi se da bi adonye sa na asechire odi pa kworo abatena parliament ya say watena ha wa say parliament we say dey many problem me MPP ni ba kuna me beto abana me ba be ye no ba kuna e beto December na ye be January 2025 no ade dey ba me ma MPP bio na ko independent na asma wo kan no sa ne o constitution ye ye se ye ti ase no say enne ye ma sorry say enne no enne ye ma jai MPP ba chod ha say many MPP want to before independent kwa independent side then constitution no wo bite I know na ye ti ase no where was
okay ma many yura and the appear could be chuchin komo honorable me machi honorable umpo to say okay yura and the appear could be lawyer kunini na enra Bagbin akoyi wo ma fi wo position enti anopa mi so mo ya minority o so mo ya de yo ene wo mo na be kire wada ma enra asema yura Bagbin ni to adwai ya asem kese pa yenti wo ba kom sem da se Ghana fo akoto aba na yese ebibi for your majority me ba chose si out me nka Mr. Momo me headline ma me why na yura ndi apia ku bi so won temika fa koseni ehwe se obeti no hanuma na bi ewe no yura ndi utemenka hello yura ndi utemenka okay me ebusa se asema yura Bagbin ndi atudwai yenyantie se majority musimo abokoto kopim se Supreme Court ebema ni interpretation mo kan say asem no Ghana fo bebre aye adwiri mu kesene
Sumpa FM
I am not surprised at the decision of the speaker. But I don't blame him also. Assemblia was the genesis. The genesis of this particular matter because 2020 we were faced with a similar situation. At the time, no. Professor Runia, very terrible and very inconsistent with law. Except that nobody challenged it. Some of us spoke against the position it took them. But law, law. What law was clear? You need to explain.
Hello. Asante. Yabeba na yabetwe nkomo na yahye. Yewra asem ni nyina ko wie se. Nipa bebre wo mo adwenkyere wo dewe. Na emom ebi mu susu nyina ka se utie Yewra Professor Azar go to article 11627. We cannot hold by-elections right after 6 months to elections. What do you mean to Sanamo? It's like 2 months. Now, in Kronkroa constituency are MPs near MPs now. Now they will not have representation for the next 2 months. It's the assembly we hear MP when they come home. What I say? And then a professor as well say by what Bagbin will deny those constituents a representation. The same thing and a sal for Mania in fear 9 a fair constituency at one of the greatest sin of the 8th parliament denying the people of Sa a representation. But in 2 months to election 4 constituencies have been denied representation. And Jacoba say, officer, ye kotuaba 2 months to election. What say MPs via vacate say because Omo a declare. Right now the question is that is an